I want to understand what the Election Commission needs to look at before calling a bypoll. And will they be cautious this time? I have S.Y. Qureshi, former CEC, joining us on the broadcast. Mr. Qureshi, thank you very much for your time here on Mirror Now. It's important for us to understand what the Election Commission does now. Because you know, since yesterday, what is being said is now a bypoll will need to be called in Wayanad. Will the Election Commission rush into it, or wait till Rahul Gandhi seeks legal redressal?
When a vacancy occurs in Parliament or in Vidhan Sabha, Election Commission has full 6 months of discretion to decide the date. And what happens is that they wait for other vacancies to happen and they club the elections together. So 6 months, there is no reason for Election Commission to act in a hurry. However, not very long ago, in a Lakshadweep case 3-4 months ago, when an MP was disqualified, within 24 hours, I read it in today's paper, the MP's statement from Lakshadweep, that within 24 hours, LokSabha Secretariat issued a notification disqualifying him because of the judgment, and immediate disqualification kicks in. There is no doubt about that. Now, the immediate notification was sent to Election Commission, and they also notified the rules. But subsequently, that MP went to the Kerala High Court, which stayed the conviction. And mind you, you have to understand, lots of people are confusing between suspension of conviction and suspension of sentence. Now, suspension of sentence is that the 3 months jail, 2 years jail will take effect after 30 days, time to appeal. But conviction, on conviction, immediately a person is stand disqualified. Now, but Election Commission doesn't have to immediately issue notification. They still have 6 months. Now, in the case of Lakshadweep, Supreme Court had to tell the Kerala High Court suspended the conviction, which means back to square one, the guy is innocent. Election Commission was asked by the Supreme Court to take back the notification for the bypoll. Election Commission to take it back. Now, all that exercise will become futile if 3 days later, a court of law, the Superior Court, suspends or stays the conviction. So they could have waited, and this undue haste was totally unnecessary. It is bad optics to me. Because it will be, if suppose it gets undone in 4 or 5 days, then where do you stand?
So should that logic that applies to the Election Commission, and as I said, the Election Commission in its wisdom so far has not moved on the case. We do not know what happens tomorrow because, you know, things have moved very quickly when it comes to Rahul Gandhi. But can we apply the same logic to the Lok Sabha Secretariat as well, sir, to say that the Lok Sabha Secretariat acted in haste as well? Because we saw what the Kerala High Court did with the Lakshadweep MP. Like, you know, technically he's back to being an MP. It's a different issue that he's not being allowed inside the Lok Sabha by the Lok Sabha Secretariat. That's a different issue.
Yeah.
But should the Secretariat have waited as well?
Yes. You know, any Secretariat, if it is routinely prompt, is to be appreciated. But if it is selectively prompt, that raises a question. In this case, Lok Sabha Secretariat, which issued the notification of disqualification within 24 hours, and even after Supreme Court staying the election by election, because of Kerala High Court staying the conviction, they have not taken the MP back into the House. They are taking their own time. Now, what is this? If they were super efficient then, why are they not super efficient now? So it is bad optics. It does leave a question mark in the mind.
You know, I'm going to ask you a controversial question, and I hope you can be honest about it, because, you know, as they say, honesty is the best sunlight. The sunlight is the best disinfectant. Mr. Qureshi, will the decision by the Election Commission be influenced by the ruling dispensation of the day, that they will have no choice if the government asks them to call a bypoll? I know it's not for the government to call the bypoll. I understand that. But still.
Well, you know, first of all, this is the wrong question to ask me, because I can't be commenting on the election commission and it can't be speculative. How will they react? But my feeling is, suppose I was in the election commission, having burnt my fingers in Lakshadweep case, I will not be in a hurry. I have full 6 months. And because it was embarrassing for the election commission, and they should not be made to go through the same embarrassment all over again.
Okay, so Mr. Qureshi, my last question then. I promise I'm not trying to ask you trick questions or for you to say anything controversial. I'm just trying to understand the issue at hand here. If the Election Commission calls a bypoll in the next 24 to 48 hours or say by Monday, what will it tell us?
No, that will show that they have learned nothing from the Lakshadweep case. Lakshadweep case is absolutely clear that there was no need for that kind of a hurry, because the possibility of the Lakshadweep case repeating itself, some court of law is staying the conviction, which will stay the entire action of the election commission and of the Lok Sabha secretariat. That may happen in the next 3 days, 4 days, 10 days, 15 days. So, having learned their lesson, if they have, they should not be repeating it. This undue hurry will look very awkward and very bad, and if they have to take it back, if the conviction is stayed, they have to take back the notification. It doesn't show them in good light at all.
Okay. Dr. Qureshi, it's always a pleasure to hear you speak, always a pleasure to hear you give clarity on issues that can be a bit technical. Thank you very much for your time here on Mirror Now. I'm putting to India's most distinguished legal eagle, Mr. Mukul Rohatgi, who is joining us on the broadcast. He's also been a former Attorney General. Mr. Rohatgi, first of all, thank you very much for your time here on Mirror Now. Mr. Rohatgi, a lot has been said about Rahul Gandhi's sentencing and his disqualification. Can you help our viewers understand how a rhetorical speech made from a political stage has ended up suspending an MP for 6 years? I mean, politicians say the darnest things all the time. By that yardstick, 30% of our MPs would have to be suspended.
On the first question, I've heard you for the last 5 minutes, and people seem to think that the action of the Secretary General of Lok Sabha was rather prompt and very fast and all that, and therefore they should have waited and all that. Let me make one thing very clear. The law does not require the Secretary General to issue any order at all. The moment a conviction is recorded by a court, disqualification takes effect automatically the next second, not even the next minute. So it was not necessary for the Lok Sabha to issue any order. Whether they did it today, tomorrow, day after, it is of no consequence, because the disqualification has attached itself to the membership of Mr. Rahul Gandhi. That's the first step. Let's be clear. Do not accuse the Secretary General or any other office in Lok Sabha, because that was wholly unnecessary. Now, that is the law. You can say that the law is unreasonable, but the facts show that when some respite was to be given from such an immediate disqualification, Mr. Gandhi himself tore up the amendment which was sought 10 years ago. So, well, then that's the law. It applies to everybody. Now, let's look at the question you asked. Well, my answer is this, that this is the law. This has been the law from 1860 as to what is defamation, and the law of disqualification has been there for years and years. Everybody knows the law, and more so the politicians. And if you ask me, I have been watching, and you have been watching, and the public has been watching, the new law which has reached in all the legislative assemblies and parliament and municipal corporations as to how the law makers are behaving. They're throwing things at each other. They're calling each other names of the worst kind. I mean, you call yourself a mature democracy or the largest democracy. Yes, largest it is, but it doesn't seem to be that mature the way things are going. And people are taking, as if it's all free for all. There is a law of the jungle. Everybody has the right to say anything. But please remember, as far back as 1860, the law was made that, if you demolish somebody's reputation or character, which jolly well takes more than half a lifetime to build in a space of few seconds, because what you say is carried across the internet to millions of users, millions of listeners on social media. So the most important thing is, the more the responsibility, the more the introspection. Now, here is a person who is in charge of a big political party, whose utterings and whose voice is heard across the nation and across the world. When you make such scandalous allegations which have no basis, there is no doubt as to what the accused meant, Mr. Gandhi meant. He meant to attack the Prime Minister, who had nothing to do with the two other persons that he named, Nirav Modi and that Lalit Modi, except that they shared a common surname. I mean, there are 10 crore people who share a surname called Modi. There may be 10 crore Sharma, there may be 5 crore Kapoors, there may be 2 crore Sethis, whatever. But here the allegation was made by a high political functionary against a high political functionary, which was a completely, below the belt, by saying, well, you are a Modi, they are Modi, are all Modi stores. I mean, there's no doubt about it. So I want to end by saying, this should be a beacon judgment. Everybody should look at it and look and feel that if we are going to say all this, this might happen to us. I think it's a judgment which is required in the current laws that we are facing.
Mr. Rohatgi, the sentence is by the book, the suspension is by the law. I understand that no rules were broken, no laws were broken. But there is the law, and then there is the spirit of the law. As a seasoned legal luminary, do you think the punishment by the Surat court and the haste with which Mr. Gandhi was suspended by the speaker was appropriate? If the Surat court has given Rahul Gandhi 1 month's time to appeal, where was the need to rush to suspend him, sir?
Sorry. I again tell you, Shreya, the effect of the Secretary General's letter is nothing. It's zero. It has no meaning. You can throw it away. The suspension or the disqualification applied the moment the judge passed the judgment. This is what I've been trying to say on TV for the last 4 hours on different channels. You do not require what was done by the So that's the law. It happens. There are some laws in contradistinction, which say that this will take effect if such and such person passes an order or is authenticated by the governor or a gazette notification is issued. Then, it takes effect. There are laws of that type also. But here the law is, it takes effect automatically. If it does, it does. What can be done about it? Either change the law. Don't blame the parliament or the secretary.
I understand that. I understand that. But let me ask you again a question on the hastiness. And I ask you this question in the backdrop of what has happened with Lakshadweep's MP Mohammad Faisal. He's sentenced to 10 years in prison for attempt to murder. He's disqualified immediately. It's as per law. The EC then orders a bypoll as per law. And then the Kerala High Court stays its sentencing and the Supreme Court cancels the bypoll. So he's back to being an MP. Of course, a different matter that the LokSabha Secretariat is not allowing him to enter.
So no, Shreya, very, very simply, we do it every day. This is not the first time this has happened. Every day this is done. The least that was required of Mr. Gandhi with a vast, material and talent of legal binds with them, all they required was they should have filed an appeal yesterday to be taken up at 4 o'clock before the appellate court. They should have requested for a stay, or should have done it today. They can do it tomorrow. The election commission is not going to act in the next 10-15 days because it takes time for them to assess the situation and then issue a notification and then actually conduct an election. In the case of the other MP, he was sentenced to 10 years. Not easy to get a stay of that nature. He was lucky to get that stay. Now here, it may be a better chance for Mr. Gandhi to take a stay, but then he should apply for a stay. He hasn't applied for a stay. What are they waiting for? And
Okay.
mind you, it's very important to note that a stay which is required for him to re-enter parliament is a stay of the conviction. That is, stay of the finding of guilt, and not
Correct.
merely a stay of 2 years. That's very important. But then what are they waiting for? You should do it. If they get a stay, things are hunky-dory. If they don't, they don't. And every day, I have done hundreds of cases where people are disqualified from different houses on account of different problems like corrupt practice, this, that, so many things. We go to the Supreme Court. Many times you do not get a stay of conviction. You get what is called a partial stay, which in lawyers' language is called the Indira Gandhi stay.
Okay.
The kind of stay Indira Gandhi got in 1975. That was a stay which said that she can go into parliament, she can take part, but she can't vote. Things like that. All that is a matter which will happen later. But then don't blame. If you blame the law, then you should challenge the law. Law is not under challenge.